Should I reopen my case? In other words, should I file a motion to reopen or to reconsider by using the form I-290B, or should I just start over with my case? We're talking primarily about those cases based on marriage, green card based on marriage. What should I exactly do? In this video, I'm going to lay out some foundations for you so that you can be able to make a better decision. My name is Bijoux, Ngwanda, as you know it. I am an immigration lawyer based here in DC. However, I do have clients across the country and around the world because we are dealing with complex U.S. immigration law cases. If you're new to my channel, please go ahead and subscribe. If you are not new, welcome back. Thank you for subscribing, and please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share, like. Don't forget to comment below. Also follow me on all platforms. Links are in the description box below. Let's get right into it. Should I reopen or should I start over? The first question you have to ask yourself is, why did you get a denial? Based on the reasons as to why you got the denial, then you can make a decision. That's the first question, right? The second question, or the last question you have to ask yourself is, what is the standard for reopening the case, and what is the standard for filing a motion to reconsider? When we go to the first question, the decision, the denial decision, why this case got denied. Let's say, for example, you filed everything and the case got denied based on failure to prove bona fide marriage. This case, just clearly, you really have to just start over. The reason you want to start over is because now that you know why they deny it, the reason they gave to you, and the previously filed document, you have all that. Now you know you can add more documentation, you can have better reasonings, and you can start over, okay? But if you ask yourself the second question and say, well, but I just want to reopen, what is the reason or the standard for reopening a case? The standard is that you have to have new facts of the case, new evidence of the case. You cannot just reiterate the thing that you already said. You cannot resubmit the same document that you previously submitted. You have to have new evidence, new facts in order for you to be able to reopen the case, okay? If you go with the standard of reconsidering motion to file a motion to reconsider, then you have to find out whether USCIS made a mistake in the case, on the law or on the policy. So this example could be, sometimes they will deny the case based on a public charge. For example, one time they made a mistake and they denied a case of a green card based on VAWA, right? It's still based on marriage, right? To a U.S. citizen or lawful permanent resident. They denied a case based on public charge. But remember, with VAWA applications, we are not subject to public charge. The VAWA self-petitioner is exempt from public charge. So that was clearly a mistake in the law. So we had to write a motion to reconsider and tell them this is a mistake in the law and in the policy. You just have to reopen and grant this green card. And it was granted. Another example was, and again, based on public charge, green card was denied. Come to find out that the person was making enough money to support at least 7 people, but they denied, they're saying that he wasn't making a lot of money. So we had to correct them and say, this is the mistake. This is what the policy says about sponsorship, the income requirement for the number of people you're supporting, household size, etc. This is a mistake in your own policy. So they had to reopen the case to reconsider the decision and, grant the green card. Another mistake could be a policy. They say, for example, they say that you filed late. You responded to the request for evidence late. Then we have to look at the policy. What does it say about responses? If you have proof enough that you responded on time, and especially under COVID, they were giving at least 90 days Sometimes they will make different type of calculations. That's a mistake too. You can reopen the case based on that. Even for naturalization, you can basically file a motion to not to reopen, but the N336, based on the fact that they miscalculated the time you were outside of the country, or based on the fact that you know, you were working outside of the country, therefore you did not abandon residency because you were working still with the same company, the American company based outside. So a lot of arguments can be made for reconsidering. What about new facts? For motion to reopen, you have to have new facts, new evidence. Again, if you have new facts, new documents, you can reopen the case. But if you have a gray area where you think that you already submitted those documents, you don't know if they're new, you're doubting a lot, it's better to just start over. Why? Because if you file a motion to reopen and get denied, you lose money and time. But if you refile with all the new documents and based on what you already know why they deny it, then you have a better chance to get it. And nowadays they are giving those work permit within 90 days from filing. You gotta spend again, but this time around with a better chance of getting it right than reopening without knowing if it's going to be granted or not. Time, money. Here, only money, right? Of course, in time, but still with a better chance of a better result. So this is it for today. If you need a consultation trying to see what is the best course of action, you should call me, or you should try to consult. Consultation, again, consultation fees apply as usual. Consultation link is in the description box below. Another thing I wanted to add about reopening those cases, filing those motions using the form I-290B. One thing you have to remember is that there's no processing times online, so it might take really a long time. And please do not go with BIA. Just try to file with USCIS by using the form I-290B. At least you have a better chance of following up with them. Another thing is, if you did not file concurrently, just know that you're going to file two motions. Motion to reopen for this I-130 and then motion to reopen for another green card, because and in certain cases really the green card is still going to be denied, because if I-130 was denied, then they have good reason to deny the green card application. Therefore, it's advisable to only file I-130. If it's get reopened, then you can submit a new form for I-485. Complicated stuff. You probably need counsel. You can get one. If you do not have one, I'm available for consultation. Consultation links are in the description box below. Until next time, bye-bye.